to the Party Center Speaks podcast. This is the podcast for family entertainment center and event venue owners, operators, managers, and staffers looking to grow their business. Want to learn about how you can increase party bookings, improve facility operations, and more? This is the podcast for you. My name is Laura Cañas, and I'm the marketing manager here at Party Center Software. In this episode, we're going to share audio from our webinar on navigating the legal landscape of digital waivers. We hope you enjoy this presentation.
As you know, today we are going to talk about navigating the legal landscape of pre-event waivers and releases. So this will be featuring Michael Amaro of Amaro Baldwin LLP. He's our legal expert for today, and he'll kind of talk you through practical tools and tips. So welcome again, everybody, for joining us. We are Party Center Software, and we're powered by our payment processing system, Party Center Pay. We turn the frustrations of manual processes into a phenomenal guest experience. So our software enables our customers to offer online party booking to their guests, digital waivers, an online store, and we help you manage your facility. Our expertise is in the FEC industry. We love working with trampoline parks, arcades, bowling alleys, but really any FEC or event venue out there. What's important to note here, though, is that we're more than just software, we're business builders. So we work really hard to provide you all with resources every month. We have an ebook and a webinar like this happening pretty much every month, as well as a customer support webinar happening at least once a quarter. We also have a very active blog. We post 3 times a week. So please be sure to check out our resource center and our blog on our website. I would also like to take a moment here to introduce our fabulous team. So first we have our success consultants, Megan and Courtney. They're here to really help with business consulting, facility planning. They provide a lot of great resources and are a great connection to industry partners. We have our awesome customer success team, Eileen, Tanya, and Jesse. They enable our customers to get the most out of our software. They provide you with marketing advice, business consulting. They regularly check in with our customers, and they're really here to support your growth efforts. We have myself, marketing manager, and a woman of many hats, Rebecca, our director of sales, marketing, and customer success. And we're here to help you with your company playbook development, marketing advice. We let you know whenever there's a great industry trade show or event going on. And we're also here to help with any sort of business consulting. So without further ado, I want to introduce Michael of Amaro Baldwin LLP. Michael, I'm sure you probably want to kind of talk a little bit about yourself and let our audience know what you'll be talking about today.
Sure, I appreciate it. Thanks for the introduction. And good morning or good afternoon, wherever you're located in our country. And welcome to the webinar today. And I appreciate everybody taking some time out of their day to join us. As Laura indicated, my name is Michael Amaro. I'm an attorney here in California, and I've been representing clients in the amusement and recreational industries for 37 years now. And we represent amusement parks and FECs and water parks and go-kart tracks, trampoline parks, skating facilities, and a whole host of other clients involved in amusement and recreation. And my law partners and our firm is in Southern California called Amaro Baldwin, and we represent clients throughout the state. So with that, we're going to be talking a little bit about waivers and releases and how they're treated a little bit differently throughout the country in the various states. And at the end, we'll be able to take some questions, whether it be through chat or I think Laura is going to kind of field some of those questions. So we'll have ample opportunity to maybe talk about some of your own unique issues. So I think in today's day and age, people are quite used to encountering waivers and releases. A number of years ago, there was a general reluctance to waivers and releases. People think, oh, I'm not going to sign my rights away. But today, encountering waivers and releases, and particularly in the recreational context, they're very common. So if we go to the next slide, and we're going to talk about some of the things that will impact whether your waiver and release, whether it's an electronic document online or whether it's a paper document, whether that's going to be enforced by the court. What's going to happen in lawyer land when you get sued and your attorney presents your waiver and release document to the judge and asking that the case be dismissed based upon the doctrine of express assumption of risk. So the biggest factor, obviously, is the language of the release itself. So we're going to talk about some of the drafting issues, some of the tricks and tools to utilize in your online or paper waiver. Another thing we're going to talk about is how does your state and the state laws, case law and statutes view the enforceability, if you will, of waivers and releases. And we're going to talk about some of the other things, such as can a parent sign a waiver and release on behalf of a minor? What sort of rules and regulations that apply there? And then, most importantly, does your state recognize use of online waivers, such as, for example, not necessarily having a signature, but making a mark or making a check or I agree? And I think almost every state now has an electronic transactions act because everybody's used to downloading software on their computer, downloading an app on their phone or ordering a movie on Apple TV, Netflix, or whatever it is. Those are all acts that would be basically accepting the terms and conditions of an agreement. It's the same as having a signature on a piece of paper. So let's go to the next slide. And in some states, unfortunately, pre-event waivers and releases are simply void against public policy. The courts in those states have said, the release waiver is really not worth the paper it's written on because we feel in our state it's what they call a contract of adhesion and it's not enforceable. So what do you do if you're in one of those states? Well, we're going to talk about some of the other provisions you can add to these documents that will provide you some additional protection, such as an arbitration agreement or arbitration provision, also an indemnity provision, and we'll kind of get into those a little bit as we go through the presentation. So in most states, though, waivers and releases, at least those given in the context of recreational events or recreational activities, are not void against public policy because they're not deemed to be essential nature, like banking and housing and healthcare. So for example, like in California, if you would go see a doctor and the doctor has you sign a full waiver and release of all claims against the doctor before you even get treatment, that's going to be void against public policy. But if I go to a trampoline park and I sign a waiver and release and I jump on the trampoline and break my ankle, that's going to be enforced. And that's the way a lot of the states do recognize waivers and releases in the recreational setting, that they're not deemed to be essential in nature and hence not void against public policy. So let's go to the next slide. In the states that do recognize the use of pre-event waivers and releases, the question arises, can a parent or legal guardian sign on behalf of a minor? There are about 12 states that have specific case law that recognizes a parent or guardian's right to waive claims on behalf of a minor. And California is one of them. And also, we're going to talk about this a little bit as well, is that some states, they do differentiate between ordinary negligence and gross negligence, or products liability as another type of cause of action. So you really want to make sure that you understand the legal landscape in your state and what kind of case law there is on the books as it applies to these pre-event waivers and releases, because that's going to be really your best tool to know the judicial nuances and trying to add this or enhance your risk management plan. So just a quick note, I'm a member of a industry group. It's called IALDA. It's the International Amusement and Leisure Defense Association, and it's ialda.org. And it's a group of attorneys and other like claims professionals around the country that specialize in types of recreational cases and amusement clients, representing those folks. And you can go on to our website and then do a search for an attorney in your state that might be able to build a relationship with you or answer any other questions you have. Or if you'd like, you can just email me directly and I can make an introduction for you based on your state. All right, so let's go to the next slide. So what are some of the things that you should try to accomplish when drafting a waiver and release document? In other words, what is the judge going to be looking at? What is he or she going to be looking for in the scope of the agreement to determine whether or not the injury producing event, what happened, the person that got injured, what happened to that person, and whether that particular incident was encompassed within the language of the agreement itself. So let's go to the next slide. The courts use an objective standard. In other words, it's not the plaintiff or the injured person saying subjectively, well, I didn't understand the terms of the agreement, or I didn't read the agreement. Not reading the agreement or not understanding it is not a valid defense in most states. The courts look at an objective standard and look at the language to see if the language utilized is reasonably clear, explicit, and sets forth an objective intent to give up certain rights about waiving claims in the event of an injury. So again, it's the language of the agreement that's going to be really critically important. So the next slide. So the key is to try and cover things that could potentially occur within your facility. I know it's hard to kind of have a crystal ball and look down the road as to all the things that could happen. And that's why it's important to build a relationship with an attorney, because over 37 years, I could tell you I've seen the wackiest of claims that get created or get made in lawyer land. I'll give you just a couple of examples. In the early days of representing 24-Hour Fitness and Valley Total Fitness, they had a club membership agreement that had a waiver and release provision. But the waiver and release language talked about getting hurt while using the exercise equipment or having some sort of an incident involved in the exercising at the facility. And it didn't have any language about medical care or treatment. And we had several cases where people have had a stroke or a heart attack while exercising or in a class or swimming in a pool. And the facility didn't provide timely first aid care treatment or did not timely call 911, or in a few cases did not have an AED device, to defibrillate somebody. And as a result of those cases many years ago, I started adding language to waivers and release agreements, talking about the scope of the waiver includes medical treatment provided or failed to be provided. So adding that particular language in your release, I think is critically important. Another example is, let's say you have a trampoline park. And the scope of your agreement relates to the use of trampolines and similar type elements. But then you add a different element. Let's say you want to increase your revenue and you add a mechanical bull or a rock wall. And then you have to go back and say, well, does the scope of the language in our release talk about those different elements? One of my clients added a mechanical bull after I drafted the initial agreement and didn't tell me about it. But luckily, the language within the agreement itself was broad enough to cover things like that and the negligence claims that were made. So again, anytime you add a new element in your facility, go back and look at whether that's objectively covered within the language of your agreement.
Michael, that's just really, really fascinating, and I think that's information that that our audience would really benefit from. I did want to jump in here and throw up our poll, actually, which is, let me just launch it really quickly for you guys. What best describes your facility? Are you an FEC, an event venue, a Ninja Warrior park, a mini golf facility, a bowling alley, soft play center? I mean, all these things will affect what goes into your waiver, right?
Absolutely, yeah, because there's different unique elements in your facility. For example, the risks involved in a shooting range or an axe throwing facility are substantially different than,
Yeah.
let's say, a paintball facility. And I've represented, all of those on that list, and we kind of customize the waivers and release agreements based on your unique elements.
Absolutely. Well, we have 44%. Come on, guys. A couple more of you so we can get at least to like 60, and I'll close this poll and we'll know more. 55, awesome. All right, we got to 60. A few more? 72. You got it, guys.
See, they're paying attention.
They are. All right, I'm gonna end this poll. So the majority of you are FECs, but we have event venues and Ninja Warrior Park, pretty much almost everyone except for shooting range or axe throwing facility. So we have laser tag, soft play. All right.
So I love those axe throwing facilities that serve alcohol. It gives rise to all kind of crazy things. All right, so let's go to the next slide. So it looks like most of you are FECs, which is good. So you're going to have, miniature golf. You're going to have maybe some go-kart tracks, arcades. You might have some, aerial courses, climbing facilities, rock walls. So again, when you're drafting your waiver and release, try to make the language as broad and as encompassing as you can, and cover some of the unique experiences that you offer at your facility. And make sure that if you're using a paper, I don't know how many people use paper waivers anymore. They're so cumbersome to keep, but online waivers like our host utilizes, I think, are fantastic. You have to have at least 10-point size. The unique thing about a document on a computer, you can enlarge it for people that have sight impairments. But you also want to make sure that you're using language that, again, expresses that objective intent to waive claims, like waiver, release, negligence, hold harmless, things like that. To the extent that you can have separate headings, a heading that says this section is acknowledgement of risks. The next section would be assumption of risks. The next section, the heading would be waiver and release. Next heading would be, let's say, arbitration or indemnity. So that, again, there's something that the judge can look at and say, hey, this objectively tells a reasonable person of what the scope of the language is and what the intent of the document is. And don't try to hide a waiver provision as part of a general sign-up form, or have a waiver and release in a paragraph at the end of a informational document or a party sign-up sheet or whatever it is. If you're going to utilize a waiver and release, utilize something like the online waiver form for our host uses in this case. All right, so let's go to the next slide. Another thing that I like to add two waiver and release provisions that most people don't think about, because you look at like the waivers and releases that are used online. A lot of folks will say, hey, I have a FEC and I want to use an online waiver. So they grab 4 or 5 of them and they take a section from this one and a section from that one, and then they kind of create their own. And that is probably not a good thing to do because it doesn't include, again, some of the unique things that you might offer in your facility. And in the releases that we draft, we always add a provision that says that the patron acknowledges that the facility is offering recreational services and there's not a sale or a lease of a product per se. And the reason that's important is that in lawyer land, plaintiffs can pursue claims of negligence, saying that you didn't exercise reasonable care, but they can also sometimes include a products liability or a strict products liability claim as part of their complaint. And the legal threshold of proving a products liability case is lower than in your typical negligence cause of action. The jury really, like in California, the jury just has to decide or find that the product, let's say it's a go-kart or something, failed to perform as safely as an ordinary consumer would expect. Or if it's a trampoline, the trampoline didn't perform as safely as the ordinary consumer would expect. So I add in our releases something to the effect of, I acknowledge that the facility is providing recreational services and there is no sale or lease of a product. And by paying admission, I obtain a non-exclusive license to use the offerings with all of the other patrons in the facility. So again, that expresses an objective intent by the person signing that you're a provider of services, recreational services. And in many cases, that type of provision has enabled us to defeat a product or strict liability claim. All right, so let's go to next slide. Again, as I mentioned before, waivers and release agreements are so common these days. And I think if you did a poll, there's probably a very high percentage of patrons that don't even read them. Like, I know what they say. I'm just going to sign it because I know that I have to execute this document as a condition of my child or myself enjoying the services that you offer. And again, case law says that it's not a defense to say I didn't read it, and it's not a defense to say I didn't understand it. So the important thing is to make sure that you have the appropriate language in the agreement so that later on, when a judge is looking at this document, the judge, he or she could say with the proverbial 20/20 hindsight, the scope of the language encompassed what occurred. And based on the language utilized, the patron said, I'm going to give up my rights, or I'm going to give up my child's rights to sue you for negligence liability. So these things are the old adage, they're definitely worth the paper they're written on, and they're definitely worth the time to make sure you get the right language in there on the front end. All right, so let's go to next slide. So for minors, this is we're in lawyer land here. So minors don't have the legal capacity to enter into contracts. So let's say you have somebody that's 17 years old and they're under 18, the legal capacity is 18 years or older. So a minor can enter into a contract. Let's say a minor can go down to the car dealer and buy a car, and then 2 months later say, I changed my mind, I'm going to turn it in. So in those states, a minor can disaffirm a contract because the minor didn't have the legal capacity to enter into the contract in the first instance. So you want to make sure that you have a parent or guardian execute the waiver and release on behalf of that minor, as opposed to the minor doing so. Now, in some states, a parent cannot, as a matter of case law, waive future claims of a minor in the context of recreational activities. For example, Colorado, Maine, Mississippi, New York, New Jersey, Pennsylvania, Rhode Island, Tennessee, Washington, Utah, and West Virginia, they all have case law that says a parent cannot legally waive claims of a minor. But again, you can add other provisions in those agreements, such as arbitration provisions, indemnity provisions. I'm going to talk about some of those things in just a few minutes. So let's go to the next slide. Oh, here we go. We're here now. So some states do, in fact, recognize a parent's right to waive claims on behalf of minors. So, for example, the state that we practice, California, is one of them. Alaska, Colorado, Connecticut, and some of these other ones listed here do allow a parent to sign a waiver and release. So the question is, what do you do to protect yourself if a state doesn't allow a waiver and release provision, to be a parent to sign a waiver and release agreement on behalf of a minor? So we add indemnity provisions or arbitration provisions in these agreements. So for example, if dad brings his kid to a trampoline facility or an FEC and signs a waiver and release on behalf of that minor, and the minor gets hurt, in the states that do recognize a parent's right to waive claims on behalf of the minor, we can effectuate an early motion for summary judgment. But adding an indemnity provision whereby dad agrees to defend and indemnify the FEC or the recreational service provider, we can then turn around, and if there's a lawsuit filed on behalf of the minor, we can say to the mom or dad, hey, you signed this agreement, and we're tendering the handling of this case to you under that express indemnity provision. And I can't tell you how many cases we've gotten dismissed once the plaintiff attorney knows that mom or dad contractually agreed to indemnify the recreational facility. Or alternatively, if the tender isn't timely accepted, we'll file a cross complaint against mom or dad. Say you have an obligation contractually to defend and indemnify us. And again, that's given rise to a lot of early dismissals in the case. Another tool that you can utilize is an arbitration provision. You can have a situation where a parent gives up the right to a trial by jury. And if there's a lawsuit filed, the recreational facility can then require the case be arbitrated as opposed to be litigated in the actual court system. And one of the benefits of that is, you can avoid the potential of a sympathetic jury in, let's say, a serious injury case. So you can get just one person, a retired judge or an arbitrator, deciding the case based on the language of the release. So sometimes that's beneficial too. And to the extent you want to add that to your waivers and releases, there are some unique case law nuances that apply in certain states, like in New Jersey, where you have to have certain language in your agreement in order to give up the rights to a jury trial. All right, so common question that gets asked quite a bit is, well, who can sign? You have a group of children that come to your facility with a camp or a baseball team or a soccer team, or grandma or grandpa brings their kids to your facility. Can a coach, a chaperone, a neighbor, babysitter, aunt, uncle, whoever, can they sign for the minors? And the simple answer to that, unfortunately, is no. The only folks that have the legal capacity to sign is a parent or legal guardian. And I know this is a common problem where a group of kids show up and they're getting checked in, and let's say you have maybe 10 of 12, the parents sign, but you don't have 2, and the coach says, oh, I'll just sign for them. You don't want that to occur. And one of the benefits of having access to an online waiver form is that your staff can call the parent on their cell phone and say, hey, log on to our website and access the online waiver and fill it out right there. It's like real time. And then once they fill it out, sign it, then it pops up on your system that you do in fact have that waiver and release form signed for that child. So again, it's just adding an additional layer of protection as part of your overall risk management plan. And the critical thing is to properly train your personnel about that point, because a lot of the staff that I've talked to say, well, I didn't think there was anything wrong if a coach or grandma signed the agreement. One of my law partner and I just got a case in where a young man was in a surfing class and grandma signed him up and signed the waiver and release on his behalf. And now he's claiming a serious injury, rather bizarre injury. But since grandma signed it rather than the parent, the waiver and release is not going to be legally effective at all. And again, it's having that good indemnity provision that I was talking about. Let's say grandma signs it and there's this indemnity provision, then you could turn around and say to the grandmother, hey, you contractually agreed to indemnify us. All right, so let's go to the next slide, which is our last slide, and then we'll open it up to some questions. There's some other common problems that I've seen with electronic signatures. I don't think anybody's signature looks the same when they sign one of those keypads at a grocery store, or at a Home Depot, or any of the types of businesses that you might frequent. I think everybody just does a quick scribble, and it no way resembles our signature on a piece of paper. So there's where the Electronic Transactions Act comes into play. The electronic transactions laws basically say that you don't even need a signature to be effective. For example, you download software, you check the box, or you watch a movie on Netflix, you double click here on your phone. The Electronic Transactions Act says that if you make a mark, or you have an act, or you click or do something to accept, that is an attestation that you're agreeing to the terms and to be bound by the legal terms of the agreement. So I always add something at the end of these waivers and release provisions that are online, that I acknowledge that by making a mark or clicking here or accepting here, that I agree to be legally bound by the terms of this agreement under the Electronic Transactions Act. And that by not having an actual signature, it will in no way impact the legal enforceability of the agreements, or something to that type of language. And then finally, before we open it up to questions, it's another good tool that I've always had our clients do is, for example, if you have an accident and you're going through your CCTV video, and you want to preserve all the camera angles of the incident and the aftercare and so forth, look also to see if earlier in the session or earlier in the day, you have video of the parent actually signing the agreement in your lobby. You know, if they're signing at home, you can't do that, but a lot of times parents will show up and they'll go on, you know, into one of your little monitors or little kiosk, and they'll fill out the waiver form right there. So grab that part of the video as well and preserve it with the incident video. It's a really helpful thing down the road. So with that, I guess, Laura, we'll open it up to some questions, I guess.
Absolutely. So we actually do have one question. In your example of timely medical attention, is that a general service, excuse me, is that a general service level or varies by state?
So it's a facility, you're not a medical doctor. You don't have medical services typically. Some of the larger amusement parks have EMTs and so forth, but you know, the duty of FECs, trampoline parks and so forth is just to exercise reasonable care in response to a medical situation. And that really is calling 911. If you have like someone has a heart attack or something, timely call 911. And that's really the general rule. There's some states that do require defibrillators, AED devices, in particular types of businesses. I think we're starting to see them more commonplace now. You see them in airports, you see them in fitness facilities. So to the extent that you do have like an AED at your facility, make sure you're complying with the standards of checking it daily and having a log and reporting that you're checking on it, making sure that your people are properly trained. So those sorts of things. So I think that in general, there's nothing specific usually on the books for medical care treatment for FECs and things like that, other than there might be something unique for AEDs and things of that nature. Hopefully that answered the question.
So we actually have another one too for you, Michael. If a group of 17-year-olds comes in, would they each need a separate waiver signed by their parent?
Yes, I know it's cumbersome. And in most states, the age of legal capacity, the age of legal majority, it's a legal term, is 18 years or older. And minors, anyone under 18, does not have the legal capacity to sign a waiver and release on their own. Now, we have had cases where a 17-year-old comes in and changes the year of his or her birthday to say that they're 18 rather than 17. And there's some states that have actually have case law in the books that says that's fraudulent, and that a 17-year-old minor cannot escape the legal effect of the waiver and release because it was fraud committed. But if you have a group of 17-year-olds, like from a baseball team, a soccer team, or a school outing, or whatever it is, the best practice is to make sure you have a waiver and release signed by each of their parents.
So Joseph, who asked that question, followed up by asking, we have many groups of camps as big as 250 kids. How would you recommend handling that?
So for camps, it's always best to try to coordinate the signing of those waivers and releases in advance. So when the camp reaches out to the parents, usually the camp's going to have their own waiver and release, so their own permission slip or whatever documents that they're going to have. So if you can try to coordinate an early execution of the waiver and release documents in advance. So whoever in your facility is coordinating with the camp counselors can make sure that the message gets out that needs to be done before they show up. And if it's not, it may cause a significant delay in use of the facility on that day. It's a cumbersome process, but usually on a camp like that, it's probably a buyout of your facility, and you may be able to spend a little bit more time on the front end checking off who's going to be there, the names, and what online waivers you have.
Love it. So we're actually getting quite a few questions here. Reagan asks, I was listening to a morning radio show this morning that had an injury lawyer on for what was designed to be humorous, but he made a very clear point that any waiver can be challenged in court, and used a case from a SoCal amusement park as an example. Is this simply a negotiation tactic?
So, anytime there's a waiver and release. So let me back up. So when I first started practicing in 1983, waivers and releases were really strictly scrutinized. They had to be perfect. The type size had to be exact. It had to have this language, had to have that language. And any drafting imperfection, the courts would strike it down. And then starting in the mid 1980s, there was a case called Halsey versus Elsinore Parachute Company. And they finally started recognizing that in the recreational context, we got to start enforcing these waivers and releases because litigation costs are devastating. And in the late 1980s, there was a case that basically use some real flowering language that says only on Draftsman's Olympus is it possible to draft a waiver and release with the complexity of a trust indenture and the brevity of a stop sign. So they recognize that anybody can attack a waiver and release. But the judicial pendulum started swinging the other way, and it's still swinging in favor of recreational operators. And although anybody can attack, or a plaintiff attorney can try to attack a waiver and release is not being encompassing enough or not having the right kind of language, the judge is going to use an objective standard. He's going to say, all right, how did this injury occur? And did the release talk about that stuff, or at least objectively have language that could or that would encompass the injury producing event? So the simple answer is anybody could try to contest it or attack it, but in our experience, we've had really great success based on having good language in on the front end, to having a good indemnity provision, because dad or mom is going to end up paying our legal fees if it's a minor. So they are worth the paper it's written on, and they are worth the time in getting good language in on the front end.
Absolutely. So Denise asks, how long should waivers be good for? A year, 6 months, or a sign at each visit?
So that's a great question. So a lot of our clients will have guests that that frequent the facility. It's not just a one-time deal. So to facilitate the ease of having to avoid having a minor sign or a parent sign each time they come in, you could say this waiver and release is good for example, a year, and it covers not only the visit to the facility on this day, but on any other future visits during the course of the year. So that's one way of accomplishing that task. You could either do it one waiver for each visit, or you could do a waiver that's good for a particular period of time, such as a year.
Thank you for that, Michael. And last question that I see from Ian, minors that are emancipated, what is the safest way to handle authenticating this information? And can they sign their own release?
So even minors, let's say a 17-year-old that's in states that do allow a minor to become emancipated, in other words, not living under their parents' roof, they still lack the legal capacity to sign a waiver and release. If there's no parent to sign that waiver and release, I mean, it could create a problem. There's no easy answer to that. In the states that do allow a parent to sign a waiver and release, there's no parent, then you have to make the choice. Do I allow this person to come in at 17, sign the waiver and release, or not? That's a tough one. It's just a matter of kind of a business sense of, is it a one-off person that, sorry, you're not 18, we can't allow you in? Or do you want to just make the exception and, risk that person potentially getting injured?
Yeah, absolutely. So Reagan asks another question. Does your firm have template waivers for customers to adopt, or is it better to send an existing one to you for review?
So we ask clients to, if they have one that they want us to review, we have them send us the one they have, and then we can redline it. It's obviously it's easier to kind of start with what you have already and then tweak it versus starting afresh. Using templates, I mean, there's certain things that we use, in our different waivers and releases that we prepare, but it's really a mistake to grab something off the internet that someone else is using and say, oh, this sounds pretty good, and I'm going to use it for my facility. Because, for example, there was a case I just encountered about a month ago where it was a yoga facility had gone in and just grabbed another waiver and release that another yoga facility was using. And that the yoga facility had an incident, really serious incident, And the waiver and release that they grabbed from this other company was the subject of a case that happened like 7 years ago, where the court struck it down and said it wasn't broad and specific enough. And we actually had a recorded case or a published case on it. So just grabbing something off the internet, it's the old adage, buyer beware, and it could be pretty negative consequences. So if you do have something, we can review it, tweak it, or if you're in another state and you want to talk to a lawyer in your state, be glad to introduce you to somebody that might be able to give you some better guidance on that too.
I love the questions. Anytime we answer one, we get another one.
That's
So
good.
Denise,
This is like free legal advice, right?
yeah, absolutely. So Denise asks, once waivers have expired, are they safe to be deleted from the point of sale system, or should they be kept for a certain period of time?
That's another great question. So in the days where we had waivers and releases that were paper, it was extremely cumbersome to store them. You got to house them someplace. With the advent of digital waivers and the cloud, it's so easy to store digital information on the cloud for really quite a long time. A minor, let's say a minor gets hurt. A minor doesn't have to file a lawsuit until a particular period of time. It's called the statute of limitations, after that minor reaches age 18. So for example, you have a 5-year-old that breaks an arm, and usually the parent is going to pursue a claim, but maybe not. So 13 years later, when that minor hits 18, that minor would have a year or 2 years, whatever your state statute of limitations is, to bring a lawsuit. So usually it doesn't happen, but 37 years, I've had 3 or 4 of those that crop up late. And it's just nice to be able to go back and look at the digital data that you have, the digital release, and maybe there's some video, CCTV video, whatever it is that you're parking somewhere on the cloud in case there is something. Again, you have to look at that and kind of balance the cost of it. If it's prohibitively expensive, and I would look at, for example, in your state, if you have somebody that's over 18 that's injured, and you have a statute of limitations of 2 years for that person to file a lawsuit, and then you have a lawyer that can go out and check the court dockets to see if that person's filed a lawsuit and they haven't, then you can kind of safely decide, okay, I'm not going to retain this data anymore, and you can delete it. But for minors, you may want to keep it for a longer period of time.
Thank you so much for that, Michael. Does anybody have any more questions? Please add them in the chat box or in the Q&A feature. Michael, this was great. I learned so much, and I know our audience learned so much. Actually, before we go, I do have one question for you. What was
Sure.
one of the wackiest claims that you got in all your time?
The wackiest claim.
Yeah.
Gosh, my wife says I should write a book someday. I've
I
had
bet
some.
you have a lot of stories.
Yeah, I've had some crazy ones. So let's see. I had one case, there's representing 24-hour fitness, where a lady was, working with a personal trainer, and then, inside the facility. And then he said, look, why don't you come over to my house? I'll talk to you about food prep and how to eat healthier, so she goes to his house and he roofies her. And crazy things happen after that. That was kind of a wacky, crazy case.
Oh my goodness. So you've seen a lot.
Yeah, I mean, it's sad, but it's, I'm just trying to think of, I had another case for Six Flags Magic Mountain, where this young man was riding this roller coaster, and he lost his Dodger hat. And this is before the Dodgers had won the World Series recently. And he had a special liking to that hat, so he talked to the attendant and said, can I go get my hat? And the attendant says, no, you can't go in where the rides are, because the roller coasters were going through there. He goes, go to guest services, give him your name, and then we'll go back and try to get your hat when the park closes and the ride stop. So he goes to guest services and he gives his name. And then he decides, I'm going to go back there and look for it. So he hops 2 fences, goes back, he's looking for his hat. He sees there's a suspended roller coaster as Batman that was below the track, and he kind of sees it going. He waits for it to go by, and he kind of crosses over because he thinks he sees his hat. But he didn't realize there was 2 roller coaster trains on the track, and then the train hit him in the head and almost killed him. So yeah, you get all kind of very interesting cases. That one we actually tried, and we got a defense verdict at trial, but
Wow.
very sad, but albeit wacky stuff.
I see in the chat box, Reagan, who asked all those great questions, said that the lawyer on the radio show she mentioned was talking about that very case, actually.
Talking about the Six Flags case?
Yep.
Okay, well, the plaintiff attorney in that case was a guy named Martin Stanley. I don't know if that's the name of the guy that was on the talk show, but he was the lawyer for the family in that case.
Yeah, might be. Well, Michael, thank you again so much for joining us today. We learned so much. And thank you to everyone who asked questions. They were great. Just so you all know, we do have a new resource that Michael helped us with. It is about digital waivers, the benefits, uses, and a comparative review of current state laws. So that chapter 3 is a long and very in-depth resource that Michael put together for every single state. So if you're looking for a little bit more information about waivers and current state laws for your state, please go check out this resource.
I hope you enjoyed today's episode. If you have any feedback or have any topics you'd like us to discuss, please be sure to email marketing@partycentersoftware.com. This podcast is a weekly podcast, so you can expect new episodes every Thursday. Party Center Speaks is powered by Party Center Software. We are a facility management tool that helps FECs and event venues book more parties and manage their facilities. We also offer marketing services such as custom website design and marketing automations to help you expand your reach and grow traffic. If you'd like to know more about us, head over to partycentersoftware.com and please be sure to give us a follow at Party Center Software on Facebook, Instagram, Pinterest, LinkedIn, TikTok, and at Party Center Soft on Twitter. Until next time, thanks for listening.